Good evening, ladies and gentlemen. This is the Municipality of Anchorage Board of Adjustment meeting of October the 8th, 2014. I'm Baron Puccio, Chair. Would you call the roll, please, first?
Baron Puccio,
Here.
John Haxby,
Here.
Robert Stewart.
Here.
Also present is Julia Tucker, Board Counsel. We have a quorum.
Thank you. You have received a copy of the agenda for tonight, and I would like you to take a quick look at it to see if there are any changes, additions, deletions.
I have a potential, just addition, I wonder if you'd like to hear it.
Just one second. Any additions, deletions, changes?
None.
Ms. Tucker?
Sometimes the agenda shows this and sometimes it doesn't, but when we get to the hearing of an EOA appeal, it's customary for the board members to do disclosures of any conflict of interest. And so you've asked me before to make sure that we indicate that, so.
Okay, thank you. I will add that. And transport is there's one new item on the agenda. I don't know if you've noticed it, and it is number 8, audience participation. And this was just brought to my attention. I don't know where this arose, but it was pointed out that under the public meetings law of the state of Alaska, there are certain public participations allowed. And so if there, and what it is really is audience participation may not concern adjudicatory matters before the board because the board may only consider the materials contained in the appeal packet. Audience participation may not include argument or testimony or other evidence. So basically what it means is, as most of the hearing tonight will concern a case that is set for decision and as to which there is no audience participation possible, it would concern the other items on the agenda, which are non-adjudicatory. And if it is that you wish to participate, audience that is, and make comments, you will be asked to do so following is agenda item number 8. So, having said that, we then come to the minutes, and seeing no other additions, deletions, the agenda stands as presented. Minutes of the previous meeting. Have we all had an opportunity to review the minutes of the regular meeting of July 31, 2014?
Yes.
Any additions, changes, deletions, corrections? I'm a stickler on names because of my last name, so feel free if there are some things, there's misspelling or anything of that sort. Anything at all? You want to take a minute to take a look? Sure.
indicates that the motion failed with a vote of 0 to 3. That refers to the main motion, right?
Yes. Okay. It does. Anything further?
I have no corrections.
Seeing no additional changes, additions, deletions, the minutes stand approved. Next item on the agenda is old business. I'm not aware of any old business, or any of you? Is there any old business? Madam Clerk, any old business? Yeah. Moving right along, new business. I'm again bringing up the issue of vacancies on this board. At present, there are only the three of us. It makes it difficult if one of us is not available or has a conflict. It is imperative that we come up, or somebody come up, with additional board members. So if you could please help out. It will be to your own benefit, because it means you don't have to show up every single time. We will rotate as we have done in years past. My idea is that if there are additional board members, whether they are alternates or regular board members, that we simply rotate hearings to lessen the burden on each of us.
I have not run across anyone that's interested in it.
So, why were we interested? Well, that's an interesting question, you know?
I think it's a civil duty.
It's a civil duty,
Self-imposed.
or are we gluttons for punishment, or?
I don't know. I think that before the new code came along, there weren't as many of these things, so it wasn't much of a damning project.
Yeah. Anyway, it is important that we come up with some additional board members or persons who are interested in applying to be appointed to this board. So if you could, please keep your eyes and ears open. Next thing, item 6B, we need to schedule a hearing on case 2014-4. And the clerk very kindly has attached, and we have in front of us a time schedule, and it appears that the last brief is due, unless our extension's granted, on November 17. And so the very first question that arises in my mind is, Ms. Tucker, are you going to be the one who will be advising the board on this case, or do you have a conflict, or are you busy, or what's your situation?
I know of no conflict on this case. In terms of parties or issues, I think what we should do is figure out when the board will be meeting on this, and then if my schedule is a conflict that would require an undue delay, then we should make alternate arrangements. It doesn't look to me, from my end of it, I usually like to allow at least 30 days from receipt of the last pleading, which would be the reply brief, before I can get a brief out to you. That's a little cramped in there in November, because the Assembly has put on a new Assembly meeting for the 25th, so for me, we have an Assembly meeting the 18th and the 25th, so in terms of actually getting to really writing this, I'd be looking at the beginning of December, so it might be best to think about when the board met, and then how, when the target date would be for, if you pick a meeting date, then the target date for when you need to have that brief, and then if I can accommodate, I will, and if the Assembly has other priorities for me, then we'll make sure that we find somebody.
Well, are you telling me that you want 30 days between the due date of Ellen's reply brief and the time that you finish your memo?
Yes, and in this case, it may be longer than 30 days on account of it's complicated by some additional
Okay.
assembly meetings and the holidays. So that's why I'm
So-
saying rather than do that, look at when you want to be meeting.
Well, what that really
Back up.
means is that
It's in the
we
January.
can't do it before the end of the year,
No.
because the last 2 weeks of December are, you know, just dead in the water anyway. And there are some of us who would like to do some other things, you know. So anyway, let me ask you, Mr. Stewart, are you planning to be out of town, let's say, the first 2 weeks in January?
Not at this time.
Okay, so Haxby?
Probably a portion of it.
Okay, would you be back, let's just grab the bull by the horn here and ask if you're going to be back on January 14th?
Possibly, I could probably do that. That
Well-
would probably work for me. I have the ability to schedule around it a little bit.
Okay,
So,
would you prefer to be the third week?
second, we could probably do that. 14th, that area would
Okay.
probably be better for me.
Okay. Mr. Stewart, 14, tentatively, January 14th?
What day of the week is that?
That's a Wednesday. We are always
Yes.
scheduling for Wednesdays. Okay. Ms. Tucker,
Yes.
would that would give you until the end of the year, basically.
Yes, it
Or
would.
wouldn't you like to do this and send it to us on December 31?
No, we don't want to see it that way.
No, but it would give you basically until well into the second week of January. Because am I wrong? If we have it a week beforehand, would that be sufficient
Yeah.
to have a memo?
Yeah, I
A
think
week
so.
before or not?
In this particular case,
In this case, no.
it would be better to have it a little sooner, but a week, I think, would work. No later than a week in advance.
So, how does that look for you?
I think that looks fine. I mean, I think that allows me to complete it in December and get it out to you, is what I think you were saying before. And
Yeah.
and that Mr. Haxby said he didn't want me spending New Year's Eve doing the brief, but I won't be doing that, yeah.
I don't want you doing that.
Yeah.
I'm
But
sure you're not going to.
Yeah, so I think that will be sufficient. Some of the-
January 14th?
Yeah, so the hearing date will be January 14th.
January
and the brief-
14 at 5:30
Okay.
here. Is that acceptable?
Yep.
Yes.
Okay. And, Julia, I just leave the bench memo date to your discretion on this. I don't think we ever had any problem with that.
I would make one note, though, that the week of January 18th through the 24th would be the week after the EP. I'm not in the office that week.
Well, I may not be here myself either,
That's
so,
Martin Luther King weekend, but it's also, so it's a short week for the clerk's office, but it's an even shorter week for Assembly Council's office, because I'm out of
Okay.
the country that week.
okay, all right. Well, so the 14th it is. Remember that if there are requests for extensions of time, and the parties agree to it, I customarily routinely approve those extensions of time. So it is possible that, that things may slip. We'll just have to wait and see. Okay? But we tentatively have this scheduled for that time, and Madam Clerk, if you would notice it out for then, I would appreciate it. Okay, next item, we are coming to the main agenda item, and that is the hearing on BOA Appeal Number 2014-3 that concerns Planning Board Resolution Number 2014-06 for case number S-12031-2, Eagle Bluff subdivision / Eagle River Area High School tracts A, B, and C. First of all, are there any disclosures concerning conflicts or possible conflicts?
None that I'm aware of.
Okay.
None.
Okay, I have none. Okay then, let us get into this case. Yes, ma'am.
Chair, just for clarification, that disclosure also can be broadened out to include any discussion of ex-parte contacts. So if you have that squared away.
Have there been any ex-parte contacts that you have had with
Outside of the...
private
With-
conversations with either party to the
No.
appeal?
None,
Okay. Or with staff or anybody else?
none,
Okay.
Or their counsel.
no.
Anything at all?
No.
Good. Neither have I.
Okay, then I would just make a clarification for the record that this evening, that I engaged in a conversation with Mr. Wheeler, who is counsel to a party in this case, but it was unrelated to the substance of the case, and had to do with a consultation with the clerk's office concerning the parameters of audience participation.
Okay. Thank you. Now, I think it would be fair to say that all of us have wrestled with this case, and our trusty lawyer here has prepared a lengthy bench memo. If I can just find it. I know I have it here somewhere in my area files. But before we get into that, I thought it might be a good idea, before we address the individual issues that have been presented, that I give each one of the two of you and myself also an opportunity to talk about this case in general terms without reference to specific issues. And by way of starting this, maybe it would be good to, so that you can gather your thoughts on this a little bit, because I have clearly thought about this beforehand. And so let me just start out with this. Where are we at this point in this case? The Supreme Court determined that Yosemite Drive must be upgraded, and that the Anchorage School District, as a subdivider, is responsible for it. And apparently both MOA and Anchorage School District agree with that determination, because they incorporated it into a development agreement that's part of the record. But after all these years, the road hasn't been improved, and no timeline has been established for the completion of those improvements. And as I review the record on appeal, there doesn't seem to be anything in there at present that provides any hope to any party that the improvements will ever be completed. Instead, the planning board, while requiring the road upgrade, granted extensions without imposing a deadline, and in fact, the 2014 plat to establish and to subdivide lots into tracts was approved without any requirement to improve the drainage. It's simply finding that there was a development agreement on record, and consequently they didn't need to address it. I think the frustrated developer here appealed and argued that the road issue would have been resolved if, as required by code, the subdivision agreement had been required. I'm sympathetic towards that, because the subdivider here is the one that is really suffering. He's also, in a way, a representative of the individuals that purchased property from him in that subdivision. And in fact, enough time has now been passed that really something should be done. How did this process get so off the track? As I read the record, in the case of a private developer, the impetus to getting improvements done is that until those improvements are done, you can't get a final plat approved. Either that, or you have to have a subdivision agreement that reaches beyond the date of the final plat recording and assures performance in the future. Here, the planning board let the school construction and opening occur, and I think that's where this case got off the track. Because at that point, the planning board lost control over the process. And the question really at this point is, how can this be fixed? Can it be fixed? And so as we think about the various issues tonight, the specific issues, to my mind, that needs to be the ultimate goal. Is there some way that we can accommodate what really needs to be done or should have been done, or are we for various reasons precluded from providing relief to the appellant? And so as I review the individual issues, and there are numerous issues here, as you can tell from the bench rule, I think that's what you need to keep in mind here, and see if we can, within the framework of the record on appeal and within the framework of what the code allows us to do, can we provide relief or not? And that's really, to me, the main issue. So, having said that, that is kind of my guiding concept here as I consider the various issues that are presented here on appeal. And if one of you or both of you have some thoughts that you would like to get rid of, so to speak, and let us know, now is the opportunity to do that.
I'll take a whack at it.
Okay?
I would agree with you up to the development of the Supreme Court and through the Superior Court. I would agree with your summary and analysis of that exactly. Somewhere the process got messed up. Sympathetic to the, I guess it's the appellant, excuse me if I use the wrong words, but I'm going to say LBJ, and the public in the area. Sympathetic to them making purchases in the area with the assurances that municipal code will see that the road is in fact constructed to the standards it was supposed to have been done. Somewhere in the process, and I'm having been a subdivider and having been through the process myself, I've seen exactly these issues come before the planning board, and I've seen exactly how this went down. And in my whole and humble opinion, many times the planning board says, enter into a development agreement, which means it goes back to the planning officer, and they reduce in writing the development agreement and a subdivision agreement. But somebody took license and said, oh, development agreement. There's no such thing in muni code, no such thing in municipal code anywhere. Old code, new code, any code that has the words development agreement with relative terms of a development agreement specified. The only thing that an agreement has to do with is a subdivision agreement. And after having fallen on that sword of a development agreement, putting something in writing like that, then either PM&E, the planning officer, or whoever else was involved in this, fell on their sword by not enforcing the muni code and issuing a certificate of occupancy or a conditional one to the school. And therefore, they are, in fact, operating illegally. It's in municipal code where they can't give them a certificate of occupancy or even a conditional one without having a subdivision agreement that states that in the code directly. So they fell on their sword. They did not put the screws to it. And there is, if we can resolve the issues of whether we do or do not have control, whether we can or can't legally do whatever we can do, the remedy, there is a remedy there there is definitely a remedy to get this road built. A government entity is determined to be a subdivider, that's stated in code, and therefore they are subject to a subdivision agreement. And a subdivision agreement, having been under one myself, has great teeth, including providing the funds to get it done on a specific time frame, and if you fail, the muni will take over the project and do it with your money. And ASD, in my opinion, is a separate operating entity. It appears that way throughout Supreme Court and Superior Court. They're a separate entity, the municipality of Anchorage. And so I think that we do have a remedy, and if we can wade through the legal issues, if we have jurisdiction, or what works, even if we say we don't have jurisdiction and the plat has expired, then they have to go through and do it all again, and then they have to do a subdivision agreement. Period. I mean, that's the way it is. That's what municipal code says. No such thing as a development agreement. Frankly, I'm shocked that anybody would abrogate the process of creating an agreement to develop a road. And this thing, 10 years, the people that are in the subdivision, which are adjacent to this, those people have an expectation through municipal code. Their subdivider did his deal. He did what he was required to do. Now ASD has to deliver. So those are my thoughts. But I would agree with you pretty much wholeheartedly as to where it needs to go in the end. How we get there is another issue.
Mr. Stewart, any thoughts? You don't have to, I mean...
I've looked at the code in depth, and I've also looked at some of the regulations. And I'm not sure if the regulations hold the same weight, but they do discuss use of development agreement, including subdivision agreement. And it's used in the context, in my estimation, of when you've got a public roadway that's already the subject, it's of an approved easement or a right-of-way, that there is the concept of using several obligating agreements in order to complete that construction in a particular right-of-way. So I guess I'm wondering what weight the regulations would have compared to the municipal code, because it does talk about that, and it's in.
Can you give us a specific reference?
Yeah, Anchorage Municipal Code Regulation, Chapter 2190, 21.90. And specifically, we'd be talking about the responsibilities of a developer. And in this case, I don't think there's any...
What section is that? Can you give it to me?
Yeah, look under 21.90.003, A sub 3.
003?
Yeah. You got a different code than I do. This was in the code.
It is confusing. The regulations are way at the end. So,
190?
yeah.
Okay. Dash 003?
Right here, read that. And in the definition section in 21.90.001, developer is defined as a party obligated under subdivision agreement, development agreement, right-of-way permit, building permit, or land use permit. And it's referring to all required road improvements, which in this particular case, it looks like it would be analogous to that.
Is there any, are there any, that's funny, because I searched through this electronically, and I did not find this. You did as
So
well?
that, yeah, you asked me to, I did too.
Yeah, and I did not find this at all. And
So-
what are these? Just a second.
These are regulations.
The regulations are supposed to explain and expound on the particular code itself.
Yet there is no reference in the code to this.
There's no reference in the code at all.
No,
No, there isn't.
But
So,
but it does use
who uses that term?
subdivision agreement, development agreement, and other obligating agreements when you're dealing with an approved easement or a right-of-way, and Yosemite Drive is in fact an approved right-of-way.
anyway, so your point is?
Well, this seems to shed some light, in my view, as to why the municipality may have been going the direction that they were going.
Okay.
But again,
I should really be
the
interested.
question then becomes, with the enforcement provisions that we're aware of in the code, I haven't really thought this through, whether those enforcement provisions would include enforcements under the regulations, and I'm guessing that it would.
You know, one of the issues, Bob, that you have is that in a subdivision agreement, okay, when you go to execute a subdivision agreement, even as it's written in the code presently, they put the teeth to, you shall bond it, provide a letter of credit, and...
Right, there's warranties and there's timeframes.
Well, there's not only warranties, I mean, there's a letter of credit for the whole project.
And bonds to back it up.
And bonds to back it up, everything. And so basically, when you either take it, if it's a $10 million project, you either take it with $10 million in the bank and say, here it is, and then here's the $2 million warranty funds, okay? So you put the $10 million in there, and if you don't perform, then the media will go in and take it, and they'll perform for you. And so, in the case of the development agreement that they executed, there are no teeth to it. Zero. And so, you know, nobody, it was just a, by gosh and by golly, and this actually really surprises me to see that in there, and are there any elements of a development agreement that show up in code? I didn't find any.
No,
But that is, we are now getting into, in fact, the first issue.
so I'm concerned as to how regulations play into this, and I wanted to bring this up so that
Well,
Julia...
we will,
has
once
time
we
to
have
think
this
about
properly on the floor, we can talk about it. The first issue then,
Well,
any
I've got one
further
more-
general discussion?
One more
Yeah.
general discussion.
Yeah.
When we're talking about official notice, is it appropriate for us to ask for official notice on regulation, or I'm sorry, on code provisions that are extant here in the code that we think are relevant and may or may not have been, well, in this case, I think they were all included in the record or in the briefs. So where is that line when we need to take official notice of something and when we don't, because it's already in the case itself?
Good. Ms. Tucker, can you address that?
Yes. The rule of thumb that I've used about this is that the concept of official notice is analogous to judicial notice. And so it applies to decisions and laws and case law and regulations. And so I don't, if something is cited and already incorporated, I'm not sure that it's a requirement that you note that you're taking official notice of it. The vehicle, how I've used official notice for the board, is to bring in something, a decision or something that hasn't been included elsewhere in the record, because it's an exception. It's not exactly true to say it's an exception, but it shouldn't be confused with not being able to take evidence. So in this case, there was a decision that was not included in your record of the planning board. But to make sense
Okay.
of the case law, it seemed appropriate to take official notice of that. Also relevant to this case was a Supreme Court opinion that, although it was cited in the briefs, was not part of the official record. So the notice is to bring things into the record that haven't been included,
Okay.
and to demonstrate that you're not bringing in evidence. You haven't opened it up for evidentiary.
And if we discuss or talk about modifications, are those usually done in the framework of each one of the issues that we would run into, or is that something we would normally hold until towards the end of the hearing?
I don't understand the question, a modification of the
Modification of
P&Z
the planning
rule.
board.
Substituting judges.
That we do at the end, as we have done before.
Okay.
That's part of the conclusion and decision. All right. Anything further before we get into the specific issues?
I guess I would just, kind of to follow up on what Mr. Stewart said. Sometimes, and I don't know if present members, I can't keep track of what present members were part of this, but sometimes what the board has done is incorporate basically, and as Chair Cruciano said, it's usually done when you make your decision at the end, but they approach the decision. So I've seen the decision approached more than one way by the board. And so one way is that the decision, I think your decision on the last case, which I didn't help you on because of a conflict in my present relationship with Mr. Starr as a client, was that you basically made as findings the issues that were brought up. So you made a finding on each issue that was brought up, and that became your findings and decision. Another approach that the board has taken, depending on the complexity and the issues raised on appeal, is that the final decision of the board was to say, okay, we're going to accept the decision that the planning board made with these modifications. And so then the whole planning board's decision, maybe 80% of it is incorporated and becomes the board's decision, but the other 20% can, change the ultimate decision as a whole. But you've had the findings, and you've made certain of the findings that the board below you made. You've made those findings and confirmed them, whether they were brought up as issues or not in the case, just so you have a complete decision. So I don't know that answered your question. That was something that was on my mind because I've seen the board handle things two different ways. And so that's something that as you get towards working through the issues and deciding how you want to approach the decision that you make, then that's something that you want to maybe talk about so that I have an idea in my mind how you're going to be organizing it, or how I can organize it for you.
My preference would be that we get out of the way some of the issues, and then I think things will become a little clearer.
Well, and as long as we're still talking general things, I wanted to thank Julie for all the time that she put into this, because this was extremely complex. Yeah, I appreciate all the
Yes,
work
it
that you
is.
put into this.
Good job.
Okay, we need to get to the issues, otherwise we will never finish this up tonight. the memorandum has a number of procedural and initial threshold, what I like to call threshold issues. And I would like to go through most of those. There are a couple that I would like to defer, and I will mention those later on. But I would like to start out with issue number 1A, and that is, are the terms, quote, development agreement, unquote, and, quote, subdivision agreement, quote, unquote, defined under Title 21. And by way of bringing this to the floor, this issue, I would ask for a positive motion.
Move that the terms, this is 1A, right?
Yes.
Move that the terms development agreement and subdivision agreement are not defined under AMC Title 21.
Okay. Second?
Second.
Okay, it's been moved and seconded. Any discussion, Mr. Stewart?
I think in the advice that we've gotten from Julia, there are a couple of things that I think that are key, and that is, and I've looked through the municipal code that's been cited, and there really is no definition of either of those terms in Title 21 under Section 2135.020 or under Section 2175.035, both which deal with definitions and rules of construction. AMC Chapter 2108 subdivision standards includes the Section 2108.060, which on subdivision agreements that are relied by several in the briefings. The subdivision agreement, I note, is required for a final plat for a subdivision to be approved. And the contents are also specified. And I note that subdivider is defined let's see. Well, it includes a governmental unit, which in this case I think ASD was recognized as a subdivider. In the Supreme Court case, which was the Board of Adjustment versus LBJ LLC, and that's quoted at 288 Pacific 3rd 87 at page 93.
Okay.
But at this point, I think I'd also like to discuss a little bit on Anchorage Municipal Code Regulation 2190, because I think that, while it deals with the same type of issue, it does indicate that development agreement is one of the various obligating documents with a developer to construct roads and other facilities within dedicated public use easements or right-of-way. And while this section deals with multiple unit residential development on a single lot or tract, it does seem to indicate a policy of using various obligating documents when you're dealing with an existing easement or publicly dedicated right-of-way. When you're doing road improvements, drainage features, etc., in those rights-of-ways. And there's also a caveat in there that procedures detailed are not to exceed what's required under a subdivision agreement.
Let us come back to the motion, however, which is the terms development agreement and subdivision agreements are not defined under Title 21. Okay. Considering that that is the motion, are you intending to vote for or against the motion?
For will mean what? Let's go through this.
That it is in fact not defined.
I would say,
No, I'm asking Mr. Stewart, because he is the one who made the motion.
Okay, I intend to support the motion.
Okay. Mr. Hagsby?
I would be for, I would be for the motion, they're not defined.
Any further comment regarding that? Mr. Hagsby, anything else?
I'd like to make one comment. Development agreement is undefined. Subdivision agreement is undefined, but the salient points of a subdivision agreement are included under Title 20.
Yes, but that is not the motion.
Yeah, then I would be for.
Any further discussions before I put in my 5 cents worth? No. I intend to vote in favor of the motion. I agree that there is no definition of either term. The peculiarity is here that the code in several instances describes what the subdivision agreement needs to contain, but it doesn't really define it. And the term development agreement doesn't show up in the code at all. It shows up, as Mr. Stewart correctly stated, in the definition, but again, we have no idea of what it means, what it is intended to be, other than that perhaps you can glean the intent from the wording of the regulation that Mr. Stewart described, but that is to a certain extent speculation. So I would vote in favor of the motion.
Can I make another comment?
Yes.
Well, a specific term, subdivision agreement is undefined in 21.08.060. It says A1, agreement is required before a final plat for a subdivision where improvements are required under 21.08.050 is approved or filed. The subdivider shall enter into a subdivision agreement with the municipality in accordance with this section. And then it goes through and details and defines what goes into a subdivision agreement. So the two words together are not in fact defined, but under here, 21.08.060, it details what in fact a subdivision agreement shall contain.
Can it contain anything else?
No? It says right here, this is what it talks about. Well, the time for complete, it talks about everything, all the details, everything that goes in there.
But what is a subdivision agreement?
It's an agreement where improvements are required under 21.08.050 is approved or filed. He shall enter into a subdivision agreement with the municipality in accordance with this section. And it says, the application for a subdivision agreement shall be made to the Department of Project Management and Engineering. The application shall include a copy of the platting summary of action, a copy of the preliminary plat, a tentative schedule of all proposed construction of public improvements and utilities, and an engineer's estimate of the cost of each required public improvement. The engineer's estimate shall be based on the schedule of prices, standard items, private development projects published by the municipal engineer. The municipality may require a showing of the subdivider's financial responsibility. And then it talks about contents. Except as provided in subsection A4 below, the subdivision agreement shall include, but need not be limited to, the following provision. And then it goes through and it specifies exactly what needs to be in it.
Mr. Chair, I have an observation.
Yes.
It would seem that, that what Mr. Haxby is addressing here could be formed in a in a motion after the board dealt with Mr. Stewart's motion. And that, to my hearing, what Mr. Haxby may wish to move as a second motion is a motion that would say, are the terms and conditions required by code for a subdivision agreement set out? And then you have two findings instead of trying to
Yes.
Okay.
mash them into one.
Mash 'em
That's
into
just
one.
an observation.
That's fine, we separated out. Great, go ahead.
Okay. Any further discussion, Mr. Stewart? Anything further?
No.
We ready to vote?
Yeah.
Okay. Madam Clerk?
You want me to repeat the motion or just?
I think we understand
We
the
understand
motion.
it.
Okay. How do you vote, Baron Gutchow?
I'm in favor of the motion.
Robert Stewart?
Aye, in favor.
John Haxby?
In favor.
Okay, the motion passes 3-0.
May I make a motion?
Yes, go ahead.
I'd like to make a motion that Julia, you may need to help me on this, is that the terms and conditions of a subdivision agreement are in fact delineated in Title 21.
And specifically, you're referring to 2108-060, correct?
21.08.060.
Okay. Second? I will second that. Mr. Haxby?
The terms, in order for somebody to file a final plat in a subdivision anywhere that there are improvements required, under section 21.0805, the subdivider, which has been in fact defined as ASD, are required to go through and enter into a subdivision agreement. All of the terms and conditions, specific code sections, guarantee requirements, schedule for payments, schedules, warranties, are defined under this section.
Okay. I agree that the section cited in the motion does describe the contents of subdivision agreements. And so I would vote in favor of the motion. Any further discussion? Mr. Haxby? And Mr. Stewart, I'm sorry.
Does there need to be a clarification that this subdivision agreement applies to the final plat?
You might not be there yet, because I think that Mr. Haxby's motion was a follow-on to the first motion.
Okay.
And so
Yep.
I would just take it step by step, because it is so complicated, and that way even if they seem like baby steps, they'll get bigger as we get farther in, right?
Okay, any further discussion? Seeing none, Madam Clerk?
How do you vote, Baron Gutchow?
Yes.
Robert Stewart?
Aye.
John Haxby?
Yes.
The motion passes 3-0.
And I have a question for the clerk. Even though you're not restating the motion, will your minutes and notes include the wording of the motion?
Exactly,
That'll be
yes.
important.
It needs to, otherwise we need to repeat the motion.
No, it will state it exactly.
Okay, very good. Let's get to issue 1B, which is, are terms and conditions required by code for subdivision agreements omitted from the development agreement dated March 22, 2013? And what this refers to is the terms and conditions required by code that we just discussed, and that is 2108-060. So, we need to put that in the form of a motion, and I'm willing to do that.
I have it down.
And I will move that terms and conditions required by code for subdivision agreements as contained in AMC 2108-060 were omitted from the development agreement dated March 22, 2013.
Second.
Seconded. I think when we compare the two, and we have
Who's
the
creating
development agreement, it's in the record right now, and we can simply refer to it. It's page 40 of the record. It's a 4-page agreement entitled Yosemite Drive Upgrade and Yosemite Drive Area Drainage Improvement Development Agreement. I have reviewed that, and while Section 1 of that agreement seems to follow pretty much what the planning board required in the preliminary plat process, does not list the crucial items that are crucial to this case, and that is what is referred to in the subdivision agreement requirements in 2108-060 as timeline, warranty, and performance guarantees. So these items, particularly the timeline, is crucial in this particular case that we are concerned with. And so I have found that there is in fact a distinction between the two, and it appears to be a crucial distinction. I therefore intend to vote for the motion. Mr. Haxby.
I would tend to agree with you. Crucial items were in fact omitted from the development agreement. Nowhere can I find, other than the code regulations that Mr. Stewart brought up, where there's any relation to the words development agreement occurring in code. And certainly before final plat can be done, the municipality is required, or the ASD is required to enter into a subdivision agreement. Salient points are not completed in the development agreement. And they need to be. So I would vote in favor of your motion.
Okay. Mr. Stewart, any comment?
I agree that the terms and conditions of the subdivision agreement are not generally included in that development agreement.
Okay. Are we ready to vote? Madam Clerk?
How do you vote, Barry Pinchot?
Yes.
Robert Stewart?
Aye.
John Haxby?
Yes.
Motion passes 3-0. Next, we come to issue number 1C. And that issue was framed as, is the development agreement dated March 22, 2013 in force and effect? And I would like to have a positive motion, please.
I'll move that the development agreement dated March 22nd, 2013 is in force and effect.
Thank you, Mr. Stewart.
Second.
Okay. It's been moved and seconded. Mr. Stewart, any discussion?
Well, the development agreement is at pages 40 and 43 of the record. And I take it this is going to be one of those items that we'll probably end up attaching to our record of a decision. But it seems to be very clear on its face. It does appear that it's formatted to actually be recorded. And all the signatures and everything were notarized. The document seems complete and ineffective. And I think it was effective on 22 March 2013.
Mr. Hagsby?
Well, it may be an agreement and effective March 22, 2013. It does not comply with Anchorage Municipal Code. And therefore, it's in violation of code. They've not included the salient requirements of an agreement that has any teeth to it. So, while it may be in force, it's my belief that we need to be modified. I don't think that it meets the standards. I don't think it meets the standards under AMC.
Well,
To
that's
me.
not the issue in all difference. The question is whether it is in force today.
What's the standard? Is it 18 months for completion?
Yes, they got an 18-month extension, that is correct. That is what the resolution of, was it April, March or April of this year referred to. That's correct.
So it gave them an 18-month extension. The development agreement does not follow municipal code. And so therefore, I do not believe that it would be in force.
Okay. Any further discussion?
Well,
Mr.
you've got
Stewart?
other contracts that are being let for the drainage and for design. Those are in the record. And if this was not in force and effect, there would be no reason for those agreements to be, for those contracts to be let.
Any further discussion before I say my last, make the last comment on this?
Go ahead.
I think there's no question but that the agreement is in force today. In reviewing the transcript of the hearing, Mr. Ayers, who was the representative of the Anchorage School District, referred to the agreement and represented to the planning board that it was a valid agreement that was in existence at the time between both the school district and the municipality of Anchorage. So I think there is, and the planning board assumed that it was in effect. When you look at the resolution of April of this year, the resolution that is now appealed, you will find that it specifically refers to that. So I think there's no question but that the parties intend, that it's the parties' intent that at present at least, that agreement is in effect. Doesn't mean that it cannot be terminated. But as far as the parties are concerned, that agreement is in fact binding as far as they are concerned. For that reason, I intend to vote for the motion. Any further discussion? Seeing none, Madam Clerk?
How do you vote, Baron Goodchild?
Yes?
Robert Stewart?
Aye.
John Haxby?
Yes.
The motion passes 3-0. Next issue is number 1D, and that is, given the litigation history, should the development agreement be appended and incorporated by reference in the decision on the application for preliminary plat approval? And I would request a positive motion.
I'll go ahead and move that the development agreement dated March 22nd, 2013 be appended and incorporated by reference in the February 5, 2014 Planning Board decision on the application for preliminary plat approval. And the don't know if I need, at this point, to include in the planning board decision modified accordingly. Or is that,
No, it is simply that that it appended, didn't
But just
make
stop.
part of, and just leave it at that. Okay. Second?
Second.
Thank you. Mr. Haxby. Mr. Stewart?
I think if you don't have this development agreement attached and made a formal part of the record here, I think it's easy for something to be lost in the historical perspective of this particular record, which is very complex. I just think it's needed in there to help clarify what's going on.
Okay. Mr. Haxby?
I would agree.
I agree also. I intend to vote for the motion. We have already found and decided that the development agreement is in force, and so I think it would be good practice to simply attach it to the planning board decision. That is clearly, the planning board was aware of the development agreement. The record shows that, the transcript shows that. In fact, one of the reasons why they did not refer to it was because they said, well, it's there already, so we don't need to do anything about it. So I think it would clarify the case if we were to append the decision to the planning board decision. If we were to append the agreement, to the planning board decision. I therefore intend to vote for the motion. Any further discussion?
Just for the record, that development agreement is mentioned in reference to testimony
Yes.
on the transcript at 17, 19, 31, 34, 35, and 37. So it's replete in the record.
Okay, thank you. Any further discussion, Mr. Haxby?
None.
Okay. Madam Clerk?
How do you vote? Baron Gutschall?
Yes.
Robert Stewart?
Aye.
John
Yes.
Haxby?
Yes.
The motion passes 3-0. The next issue is the judicial notice, concerns the judicial notice. And the way the issue has been framed is, does the Board of Adjustment take official notice of, one, the planning board's June 1, 2005 findings of fact and decision included in the official record of the 2005 Board of Adjustment appeal of that decision at pages 163 to 169, and two, Anchorage Board of Adjustment versus LBJ LLC 228 P. 3rd 87, Alaska 2010. That was the Supreme Court case for comparative analysis with the 2013 development agreement to clarify the record without remand. And I would like to have a positive motion on this, and maybe I should simply do it myself to take the burden off the two of you. I move that the Board of Adjustment take official notice of, one, the Planning Board's June 1, 2005 findings of fact and decision included in the official record of the 2005 Board of Adjustment appeal of that decision at pages 163 to 169, and two, Anchorage Board of Adjustment versus LBJ LLC 228 P. 3rd 87, Alaska 2010, for comparative analysis with the 2013 development agreement to clarify the record. You have a second, please?
Second.
Mr. Haxby will second that. I think it would clarify the record. As we proceed to the substantive issues, I think it would clarify matters if we simply include it, and if we take official notice of these two items, the Planning Board's 2005 decision, which we have, and the LBJ case, Anchorage Board of Adjustment versus LBJ, the Supreme Court decision of 2010. And I think it is important to have those in front of us so that we can easily refer to them and have further substantive discussions regarding those. So it's for that reason that I intend to move in favor of the motion. Mr. Hess.
I would agree, no further discussion.
Okay. Mr. Stewart.
I concur.
Okay. Madam Clerk.
How do you vote, Baron Gutschall?
Yes.
Robert Stewart?
Aye.
John Hexby?
Yes.
The motion passes 3-0. And now I would like to delay discussion of issues 1F and 1H, because I think it will become a little clearer a little bit later where we are heading, and go directly to issue 1G, which is, does the Board of Adjustment find substantial evidence in the record and substitute its judgment on a factual matter to find standards A through H under Section 11 of the June 1, 2005 Planning Board decision are restated in full in Sections 1, subsection A of the 2013 Development Agreement. May I have a positive motion, please?
Take it.
Move that the Board of Adjustment find substantial evidence in the record and substitute its judgment on a factual matter to find standards A through H under Section 11 of the June 1, 2005 Planning Board decision are restated in full in Section 1, Subdivision A, or Subsection A of the March 22nd, 2013 Development Agreement.
Thank you. Has been moved
Second.
and seconded by Mr. Haxby. Mr. Stewart.
The development agreement is included in the record with its attachments at pages 40 through 53, and it's also referenced in the transcript at pages 17, 19, 31, 34, 35, and 37. I note also that the relevant urban collector street standards were included in the staff packets, and that was at the transcript, page 17. And the conditions were also included in the previous preliminary plat approval by the Planning Board on their March 7, 2012 decision. That's in the transcript at page 16, and the record at page 24, and in the development agreement, record 25. And they are not, or they're absent from the conditions of the preliminary plat approval. In resolution, the Planning Board Resolution 2014-006 dated April 2, 2014, which is set forth in the record at pages 13 and 15. Section 1A of the development agreement sets out the requirement for ASD to upgrade Yosemite Drive to urban collector standards with the itemized conditions, and the conditions are restated in Section 1A of the development agreement, and they are the same standards included as A through H in Section 11 of the June 1, 2005 Planning Board decision.
Do you intend to vote for the motion?
I intend to vote for.
Mr. Haxby.
The standards A through H under Section 11 are in fact included in their June 1, 2005 decision. They left out one section, Section 12, which discussed, it said unless alternate funding for the road and drainage improvements was obtained by the municipality of Anchorage, school district shall enter into a development agreement for the above stated improvements before the final plat is recorded. So,
But we're not talking about section 12. We're
This
only-
is-
okay, so we'll come back to that on the second motion. Okay, that's fine, okay. Then I would vote yes.
Madam Clerk?
How do you vote, Baron Gutschall?
Yes.
Robert Stewart?
Aye.
John Haxby?
Yes.
Motion passes 3-0.
I'd like to make a motion, please.
Go ahead.
Well, I'd like to make a motion that, under subsection A, of the 2013 development agreement, that item number 12 of the June 1, 2005 planning board decision was not included in the development agreement.
I will second that. Any discussion, Mr. Haxby?
For discussion, under the development agreement, it talks about other anticipated improvements, including the pipe, storm drain, and landscaping. The ASD requested a state grant to provide funding for these improvements. It was pretty specific under the planning board decision that unless alternate funding was obtained by the municipality, that ASD would enter into a development agreement for the above stated improvements before a final plat is recorded. It's pretty specific. It's not included. That's a pretty definite term.
I seconded that, didn't I? I'm sorry, Madam Clerk?
Yes, you did.
Thank you. I agree that Section 12 of the 2005 Planning Board decision is not verbatim repeated. The only reference that I can find in the development agreement that in any way relates to this issue of funding is contained at the top of page 2 of the development agreement. First sentence, additional funding is necessary to complete the design and construction of the project. PM&E currently has a state grant request in for the funding to complete the project. Does that refer only to the drainage issue? It could be interpreted that way. In any event, I find that the requirement that was contained in the 2005 Planning Board decision regarding the obligations of the school district are not contained in the development agreement. Would therefore vote for the motion.
Bob?
Any further discussion? Mr. Stewart?
I think while the development agreement doesn't contain that, the development agreement is in existence. It's complied with the section 12.
Well, let me make additional comments here. There is in fact a section on top, C1, it is entitled, page 2. C2, ASD shall provide full funding for the Yosemite Drive upgrade project, and such funds will be made available to PM&E to facilitate the project, etc., etc. It's expressly understood that ASD shall provide funds to finance the actual cost of all work. So, while Section 12 has not been repeated, there is in fact in Section 12 a mandate by the planning board: the school district shall enter into a development agreement for the above stated improvements before the final plat is recorded. And that's in fact what they have done. So it is in fact, while there is not a verbatim recital of that, there is no need for it because the school district has in fact entered into a development agreement. So there's no reason to repeat the recital of paragraph 12 in the development agreement. Isn't that true, Mr. Haxton?
Under Section C of the Development Agreement, C3 actually, it says PM&E shall continue to provide all funding necessary to complete the Yosemite Drive area drainage project.
That's the drainage.
That's the drainage. However, as it appears, I don't know that that's ever been done. And so, if PM&E can't provide it, ASD has to. And it's a salient point. If you can't do it, I will. And that's not stated in this agreement. It's basically not, it was a condition of approval by the planning board. In order to do this, if alternate funding cannot be found, then you will provide it. I mean, basically, that's what the planning board said. If additional funding can't be found, I don't care where it's from, U.S. government, anybody else, city, state, feds, you name it, then ASD, you're on the hook. And that's not what the development agreement says.
Wouldn't the,
Now, subdivision agreement would wade through.
Just a second, just a second.
wouldn't the fact that the PM&E is going to provide the necessary funding be an alternate funding source?
That's what they say. But that's what PM&E says, okay? PM&E says, yeah, we'll do it. There's no hook to it, so if they fall on their sword, according to the planning board decision, we don't care about anybody else. If the funds aren't found, you're on the hook. It doesn't state that. It does not state that in the development agreement. You are on the hook if these guys don't come out. Come to the party and deliver the funds.
Well, except they are not on the hook because PM&E has agreed to fund it.
But that's not what the planning board said. Unless alternate funding for the road drainage improvements is obtained by the municipality of Anchorage, the school district shall be on the hook. That's what they're saying. If the muni can't find it,
No, that's not what it says. It says in number 3, PM&E shall continue to provide all funding necessary to complete the Yosemite Drive area drainage project.
sure, that's what the agreement says.
Yeah.
Okay? I concur with you there. But what the planning board said is unless alternate funding is obtained by the muni, then is obtained by the municipality of Anchorage, the school district shall enter into a development agreement for the above stated improvements before the final plat is reported. So the planning board's decision was pretty kind of dry. They said, we don't care if the muni can't come up with the funds, you're on the hook. And the agreement doesn't state that. The agreement says, PM&E says, oh, we'll fund it. But it doesn't say if we can't fund it, you will fund it.
Mr. Chair?
Yes, Madam. Yes.
I think that this was, I think that during the planning board hearing before, one of the rationales for not including the development agreement and the conditions, because there was already an agreement in place, goes to what Mr. Haxby is talking about here. And I think that the way that the agreement has been construed in the way that I've offered to the board here is that the conditions are listed out there in number 11. And then at the time that in 6105, at the time that they're issuing this opinion, they're saying unless alternate funding for the road and drainage improvements is obtained by the municipality, the school district shall enter into a development agreement. And so, of course, they did. And so here is the development agreement. So I think that's what you were talking about, is that they're not going to repeat the condition of entering into an agreement when they've executed that condition by entering into a development agreement. And I think that what I hear Mr. Haxby saying is that, well, even if they entered into the development agreement, he sees some missing links. And I think that those missing links, may be explored, but the first clause here is either they find funding or they enter into a development agreement. And
For those.
for the road and drainage improvements.
For the road
So the
and-
road improvements are listed up
Under
there. And those
section.
are A through H.
A through H shown as 1 through 8 on the development agreement.
So here they are, and either you find funding for them or you enter into a development agreement.
Okay, but they also said for road and drainage. Road and drainage, okay, so they entered into it for the road, the drainage failed.
No, how can you say the drainage failed? The city agreed to pay for
Well,
it.
the city agreed to pay for it, but they didn't get the funding.
How do you know?
Project isn't done.
That doesn't mean that it wasn't funded. We don't know whether it was funded or not. The school district has found somebody to pay for the drainage. In this case, it's the Muni. And that's what the development agreement states. So, I do not
Okay.
see,
Okay?
I do not see how the development agreement differs in any way from the directive given by the planning board. Either you come up with funding yourself, or either you find somebody else to fund this, I'm sorry, or a portion of it, or else you need to enter into a development agreement. And so they entered into a development agreement. Part of that is that they said, we will pay for some of it, and you, Muni, will pay for the rest.
And the Muni agreed.
And the Muni agreed.
So what happens? So what happens if the ASD says, okay, we'll build the road, here are all the funds for the road, and then the Muni says, oh, we're not going to pay for the drainage. What happens then? What happens even if the assembly denies it, says, no, we didn't pay for the drainage? Screw it, it's your deal. Does the road never get built?
No, the road would get built, the drainage may not get done.
They want the Corps of Engineers, EPA, those guys won't let it be built without.
We don't know, we don't know. There is, and I agree with you, in my mind, there is a question as to the enforceability of this. I think that's true. But until that, nobody has mentioned it, there's nothing in the record, there may be money set aside for it, who knows? We don't know. It's not part of the record. It hasn't been brought up by anyone. So we need to come back to the motion. Does item 12 of the planning board decision, is that included or not in the development agreement? And I think while technically it is not while it is technically not included, the intent is there, quite frankly. The school district complied with the mandate of the planning board. And so there's no need to repeat, for that reason, there's no need to repeat paragraph 12 in the development agreement, because it is already in there. And so I would vote, I think I will vote against the motion for that reason, because it is in there.
Okay.
Mr. Stewart?
Well, the development agreement's already an executed agreement. It complies, it's done with the planning board envisioned in 12. So it's already executed.
Yes. Okay. Mr. Hagsby, anything further?
Nope.
All right. Madam Clerk?
How do you vote? Barrett Goodchild?
No.
Robert Stewart?
Nay.
John Hacksby?
No.
Motion fails by a vote of 0 to 3. All right, let's go to issue 2. As I said before, I would like to leave issue 1H for the time being and move to issue 2. Does the doctrine of collateral estoppel bar the Board of Adjustment from rehearing the issue of whether ASD falls within the definition of a subdivider under AMC 2175 and 35E? Could I have a positive motion, please?
Not a lawyer, Bob, go ahead.
Move that the doctrine of collateral estoppel bars the Board of Adjustment from rehearing the issue on whether ASD falls within the definition of subdivider under AMC 2175-035B.
I will second that. Mr. Stewart?
Well, I think it's pretty clear that the principle of collateral estoppel applies in administrative proceedings, and that's set out in Connitz versus Alaska State Commission on Human Rights, 325 Pacific 3rd, 503 at page 507, footnote 26, and that's Alaska 2014. So in this case, you've got a party, collateral estoppel keeps a party from relitigating an issue of fact if the party against whom the preclusion is employed was a party to or in privity with the party in the first action. 2, the issue is precluded from litigation, is identical to the issue decided in the first action. 3, the issue is resolved in the first action by final judgment on the merits, which in this case we have. And the determination of the issue was essential to the final judgment. And that's set forth in Bachner Company, Inc. versus Reed, 315 Pacific 3rd, 1184, at page 1189, Alaska, 2013. In this case, while the relationship between ASD and the municipality was not raised in the Supreme Court case, the Alaska Supreme Court did adopt the reasoning of the Superior Court. And as a subdivider, ASD is treated no differently under the Municipal Code Title 21 requirements. And it must upgrade the road prior to approval of the final plat. And that's in Anchorage Board of Adjustment versus LBJ LLC 228 Pacific 3rd 87 at page 83, or 93, I'm sorry.
As the seconder, I agree with Mr. Stewart's statement, and I intend to vote in favor of the motion. Mr. Hagsby, any discussion?
I would agree. Superior Court found that they would be treated as a subdivider. Determined under municipal code that a governmental unit is determined as a subdivider. I don't think that we need to. I don't think it's up to us to make any changes to that. We've got notice.
I apologize to everybody. I failed to turn off something.
So I would vote yes.
Okay. Mr. Stewart, any further discussion?
I intend to support.
Okay. Madam Clerk?
How do you vote, Mayor Duchamp?
Yes.
Robert Stewart? Ron Hagsby?
Yes.
Motion passes through to 0. Issue number 3. Does the record support a finding that the MOA can never enter into a subdivision agreement with ASD because ASD is synonymous with MOA? Can I have a positive motion, please? Mr. Hagsby?
Give this one to me on it.
Let me paraphrase the motion for you. The record supports a finding that the record does not support a finding that the MOA can never enter into a subdivision agreement with ASD because ASD is synonymous with MOA.
I like it.
Okay.
I make that motion.
All right, and Mr. Stewart will second that. And Mr. Hagsby, discuss your motion, please.
In several areas, I think that, I think in both the Superior Court and in both the Supreme Court lawsuits, I think that it found that, or stated somewhere that ASD and the municipality of Anchorage are in fact separate entities. And ASD is a governmental unit under Anchorage Municipal Code, and therefore would be treated like any other interested party who has a financial vested interest in a subdivision. So for those facts, I would think that ASD would be required to enter into a subdivision agreement under all standards of the municipal code. And I don't believe that ASD can be treated at all synonymously with MOA. They're their own budget group. The only thing that the municipality of Anchorage does is approves the yearly budget. They don't get into the details or modify it. And so ASD is a separate entity stated in code. And it's in fact how they were treated. They executed an agreement as, in my opinion, which is not an agreement with Anchorage Municipal Code, in accordance with Anchorage Municipal Code, but they did enter into an agreement as a subdivider. So,
Okay. Mr. Stewart?
Were you referring to the development agreement? Okay. But they also apparently had entered into a subdivision agreement that the notice of that agreement was recorded June 2nd, 2005. And that's listed as item 16 on the certificate to plat. And then it also notes that the road agreement does not create a lien on the property, referring to that subdivision agreement. So there is some notice, at least, that the municipality of Anchorage and the school district, in fact, did engage in a subdivision agreement at one point in time. We don't have anything else on the record other than that. But the notice of the agreement is in the record.
but we have no such mention of,
Mr. Hexby?
we have no such notice of it anywhere in the record other than right here. We don't know what a subdivision agreement is. We have no notice of it. Is that term intermixed with development agreement?
No.
Is there some type of other agreement that we're unaware of? It would appear so.
This lists a subdivision agreement.
Let us get back to the motion. The motion is,
The record
does not support a finding that MOA can never enter into a subdivision agreement with ASD because ASD is synonymous with MOA. That is the motion I would like you to address.
The record does not.
Restrict yourself to that. Any further discussion? I have my 5 cents worth that I would like to add. I don't understand how the municipality of Anchorage, in its brief, can take the position that the two entities are identical. It simply makes no sense. The Supreme Court held that the school district was a subdivider. Subdividers can enter into subdivision agreements. In fact, there is evidence in the record that a subdivision agreement was entered into between the municipality and the school district. So it is clear that the parties themselves, that is, MOA and the school district, did not consider the school district and MOA to be one and the same. So for that reason, I would support the motion. Any further discussion? Seeing none, Madam Clerk?
How do you vote, Darrell Winchell?
Yes.
Robert Stewart?
Aye.
John Paxton?
Yes. The motion passes 3-0. Issue number 4. Before we get to number 4, please note, 7:15. My intention is that we go for another 15 minutes and then take a break. That's acceptable?
Yes.
Okay. So let's get to issue number 4, which is other protections afforded under Title 21 for the sole protection of the municipality as a local government entity to the exclusion of the public individually or collectively. May I have a positive motion regarding this issue, please?
Move that the protections afforded under Title 21 are not for the sole protection of the municipality of Anchorage as a local government entity to the exclusion of the public individually or collectively.
Second.
Been moved and seconded. Mr. Stewart?
I think in their brief, Appellant LBJ points out that the developers need to construct their projects in a manner that's safe for the public. That's on the LBJ's reply brief at page 4. And it looks like there are sections in the municipal code, specifically at AMC 2125. It's entitled Enforcement Violations and Penalties, and that includes a section on private enforcement actions under 212535. So there's a number of enforcement actions that can be taken under that I guess you call it subparagraph. So I think with that in mind, obviously, someone that's impacted and lives within proximity and meets that proximity required under the code, they can in fact seek enforcement actions and through the procedures that are available under the municipal code.
Mr. Yatsky.
I believe that LBJ's position is supported. In fact, in the code, there are numerous areas in 21.15.110 that talk about where planning authorities have the right that if size or location of subdivision may cause the subdivision to have substantial effect on the surrounding neighborhood. Also, aggrieved persons under 21.25.035 under private enforcement actions. There are also numerous other areas in the code, including certificates of occupancy for the, I think it's 21.15.150. Under item C4, talking about adverse impact on natural features, wetlands, steep slopes, existing mature vegetation, existing development, or public safety. These agreements, and I think part of them are not just for, and they've been explained to me in the past, these are not just for the benefit of the municipality, but they're for the benefit of other people in adjoining and surrounding areas, to make sure that if the guy who does the subdivision down the street does his half of the job, somebody else comes in and does the other side of it, they have to take care of it and complete those improvements. Homeowners go into places all around the city, and they say, well, that other side of the road has to be built by whoever develops that property over there. They make purchases based upon that. And typically, these issues are recorded, the agreements are recorded, and are shown on plat notes. So I would say that they are not to the exclusion of the public, and they're not solely only for the benefit of the municipality.
Mr. Stewart, any further comments?
None.
I intend to vote in favor of the motion for the reasons stated by Mr. Stewart and Mr. Yatsky. Madam Clerk?
How do you vote, Barry Fitzgerald?
Yes.
Robert Stewart?
Aye.
Tom Hetzke?
Yes.
The motion passes 3-0. We now come to issue number 5. And it's the last one we will discuss here before we take a break. And the issue is, does AMC Title 21 require a subdivision agreement prior to a preliminary plat approval. And may I have a motion, please?
AMC, I'd like to make a motion that AMC Title 21 does require a subdivision agreement prior to preliminary plat approval.
Second.
Second.
Mr. Hicks.
Under 21.08.060 subdivision agreements, an agreement is required. That is defined as a subdivision agreement. The same points of a subdivision agreement are listed under 21.08.060. And further to that includes all of the guarantees, performance bonds, warranties, etc. And it's a requirement under Section 1, before a final plat for a subdivision where improvements are required under Section 21.08.050 is approved or filed.
What do you read that from? From what section?
21.08.060, subdivision agreements. Under A, it says agreement required, application and contents. A1, agreement required before a final plat for a subdivision where improvements are required under Section 21.08.050 is approved or filed. The subdivider shall enter into a subdivision agreement with the municipality in accordance with this section.
Okay. But may I draw your attention to your motion which says AMC Title 21 requires a subdivision agreement prior to a preliminary plat, approval. 21.08.060 says before final plat is approved or filed.
Or filed.
So we are talking about the difference between a preliminary plat and a final plat. Regarding the motion?
I think that the section that he read there is quite clear. The section itself does refer to final plats, and that there's no requirement that that the subdivision agreement be entered into for a preliminary plat.
Does that help you, Mr. Hagsby?
Run that by me again, Bob, please.
I think that the section you read from, which is 21.08.060, A1, that section on subdivision agreements, it refers to the final plat, not the preliminary plat. So there's no requirement for the preliminary plat and a subdivision agreement before it's approved for a preliminary plat. Final plat, different story.
And while Mr. Hagsby cogitates on that issue, let me just add my 5 cents worth. I think that is perfectly logical because it seems to me that there's no need for a subdivision agreement prior to a preliminary plat being approved. To my way of thinking, the whole purpose of a subdivision agreement is to make sure that after the final plat is approved, that there's an agreement in place whereby certain obligations of the subdivider can be enforced and are spelled out. That creates an enforcement mechanism, for example. and standards which have to be complied with, because once the final plat has been approved, the planning board no longer has any control of the situation. That's the whole purpose for, to my way of thinking, of the subdivision agreement, to make sure that there's something there that instead of being able to run back to the planning board, you look at the agreement and somebody enforces the agreement. And as we previously said, it could be a private party that enforces the subdivision agreement. Okay? So there is no need for a subdivision agreement before the final plat is approved. And that's in fact what the code seems to say. And so for that reason, I would vote in favor of the motion. Does it require, I would vote against the motion, I'm sorry. I would vote against the motion.
Okay. I'm ready.
Does that make sense?
Yep, it does.
Mr. Stewart, any further discussion?
None.
Okay. Madam Clerk?
How do you vote, Barry Goodchild?
No?
Robert Stewart?
Nay.
John Hacksby?
No? I'd like to make a motion, please.
Just 1 second. The motion fails on a vote of 0 to 3. Mr. Hacksby?
I'd like to make a motion that AMC Title 21 requires a subdivision agreement prior to a final plat approval.
I'll second that. Mr. Hacksby?
All over in code, in section start with the first one. 21.08.060 subdivision agreement. Section A, agreement required application contents. Agreement required before a final plat for a subdivision where improvements are required under 21.08.050 is approved or filed. Subdivider shall enter into a subdivision agreement with the municipality of Anchorage in accordance with this section. Additionally, there are other enforcement actions let me just state, there are subdivision standards under 21.75, scope and applicability of subdivision regulations, definitions, rules of construction, 21.75.035, also under 21.15.150, requirements for the issuance of a building permit under Title 21. Under Section D, phasing of installation for subdivision, all required improvements shall be constructed and accepted by the municipality before any certificate of occupancy, conditional or unconditional, is issued for the permitted construction. If the municipal engineer determines that it is not reasonable to require compliance with the preceding sentence, no permit may be issued until the applicant enters into an agreement for the construction of the required improvements with performance guarantees in the form required for subdivision improvements under Chapter 21.87. And so, before they go for a final plat approval, they have to enter into subdivision.
I seconded that. It is clear to me that the code requires a subdivision agreement for a final plat to be recorded or filed or approved. For that reason, I'm looking at support for that. I'm looking at 21.6081. It's for that reason that I intend to vote for the motion. Mr. Stewart?
I intend to support the motion.
Any further discussion? Seeing none, Madam Clerk?
How do you vote, Barry Goodchild?
Yes.
Stewart.
Aye.
John Hexby.
Aye.
Motion passes 3-0.